While the national spotlight tends to stay fixed on what's unfolding in Washington, be it legislative battles, executive branch maneuvers, or endless back and forth over gun control policies, it's easy to forget that plenty of serious developments are still happening at the state level. For every headline coming out of Capitol Hill, there are countless quiet efforts in state legislatures aimed at wearing down the rights of responsible gun owners. One of the most relentless battlegrounds for this kind of fight has been California. If you've been in the gun community for any length of time, it almost feels routine to hear about new restrictions being rolled out there, tighter laws, fresh permit requirements, and an overall anti-Second Amendment attitude backed by the state government. But every once in a while, the tide shifts. Instead of more overreach, we see a win. And that's exactly what just happened in federal court out in the Southern District of California. Let's dig into it. The Hoffman case, a legal turning point. Back on the 1st of July 2025, a federal judge, Kathy Ann Benitez, handed down a game-changing decision in the case of Hoffman versus Bonta. Her ruling shook the legal ground beneath one of California's more controversial firearm policies, its outright refusal to let non-residents apply for carry permits. This wasn't a temporary delay or some procedural technicality, it was a decisive summary judgment. Judge Benitez flat out declared the ban unconstitutional. Now, to be clear, this wasn't about Californians trying to get their own carry licenses. This was about lawful gun owners from outside the state, people who may have training, valid permits in their home states, and no disqualifying history being blocked simply because they didn't live within California's borders. And believe it or not, the state's legal defense argued that folks who don't live in California don't count as the people under the Constitution. That kind of logic should raise eyebrows in any state, not just out west. Thankfully, Judge Benitez didn't buy it. She didn't just question the argument, she dismantled it. Her decision has opened the door to a broader legal challenge against state-level efforts to limit rights based on residency. A win that reaches beyond California. What sets this case apart is the scope. In past victories, the wins were often narrow, only applying to the plaintiffs who brought the case, or maybe a specific gun rights organization. We've seen decisions where the legal impact was real but limited. This time, it's a different story. The court didn't just grant relief to one person, it struck down the entire statute. The whole law that said non-residents couldn't even apply for a carry permit, gone. And that matters because it wasn't a piecemeal decision, it applies across the board. Even more importantly, the ruling challenges the idea that rights under the Second Amendment are somehow dependent on your zip code. That argument has been floating around in anti-gun circles for too long. With this decision, the precedent is clear. Constitutional protections belong to individuals, not just residents. And if California can't get away with it, neither can other states trying to pull the same stunt. A national ripple effect. Even though this case originated in California, it sends a clear message to every state. If you're enforcing gun laws based solely on residency, you're skating on thin constitutional ice. The decision puts other states on alert. If they try to deny rights to lawful non-residents, they may face similar legal consequences. It also builds directly on the legal framework established in New York State Rifle and Pistol Association versus Bruin, where the Supreme Court made it crystal clear the right to carry a firearm is not a second-class right that can be denied arbitrarily. Judge Benitez took that framework and applied it directly to California's statewide ban, setting a strong example that lower courts across the country can follow. And that's the key takeaway. Sometimes the battles that reshape the Second Amendment landscape don't happen in the halls of Congress, they happen in district courtrooms, quietly but powerfully. This case is one of those moments. It reminds us that constitutional rights aren't privileges that can be rationed out, they're guaranteed protections that follow every American, no matter what state line they cross. What this means, if you live in California, there's been some grumbling, and it's understandable. If you're a law-abiding Californian who's done everything by the book and still finds yourself jumping through endless hoops or getting flat out denied for a carry permit, this ruling might feel like a win for everyone but you. But here's the thing. Even if this case doesn't directly rewrite the rules for California residents, it absolutely shakes the legal foundation those rules stand on. By saying the state can't deny carry rights just because someone lives out of state, the court is also calling into question the logic used to enforce other restrictions like county-by-county permit delays, inconsistent approval standards, and red tape designed to wear applicants down. This case plants a flag. It gives future legal challenges a stronger footing. It makes it harder for the state to justify arbitrary, geography-based licensing schemes. So, no, it doesn't flip the switch for Californians overnight, but it does crack open the door. It gives Second Amendment advocates new tools to fight with, and it signals that the tide is starting to turn. If you live in California, this isn't the end, but it's a solid beginning. And it's a moment worth paying attention to. The legislative counterstrike. Assembly Bill 1078. It should come as no surprise that California's politicians aren't backing down. As judicial rulings begin peeling back the layers of the state's restrictive gun laws, lawmakers are already regrouping, this time pushing back with Assembly Bill 1078. You've probably caught whispers of it already. The headline grabber so far is the proposed monthly cap on firearm purchases, limiting buyers to just 3 guns every 30 days, a direct reaction to prior court rulings that overturned the previous one per month limit. But buried deeper in the bill lies something even more calculated, a new system for issuing carry permits to non-residents. Here's what's really happening. If Assembly Bill 1078 gets the governor's signature, California would technically begin allowing non-residents to apply for carry licenses. But don't be fooled into thinking it's a win. The state would retain full control over the process, imposing a mountain of requirements, psychological screenings, live fire qualification courses, hefty administrative fees, declarations specific to each county, and short permit durations. In essence, the same bureaucratic gauntlet that Californians have dealt with for decades would simply be extended to everyone else. On paper, it might appear like a compromise. In reality, it's a calculated maneuver to undermine recent court decisions by appearing to fix the issue legislatively. By creating a narrow, state-controlled pathway for non-resident permits, California can argue in court that the judiciary no longer needs to get involved. But that argument hides a bigger danger. If this bill becomes law, it could make Hoffman versus Bonta feel like a moot point, giving lawmakers the upper hand in saying, "We already addressed that." This isn't reform, it's strategic deflection. Assembly Bill 1078 is not about restoring rights, it's about maintaining control under a different name, and that's exactly why it deserves close scrutiny. Zooming out, where we're headed. Let's be clear, this recent court ruling does not mean California is now a constitutional carry state. It didn't strike down the permitting system altogether. It doesn't require the state to honor carry permits issued in other jurisdictions. And it certainly doesn't mean the legal battle is over. But what it did do was deliver a powerful message. You cannot exclude someone from exercising their rights just because their home address sits outside state lines. Still, we're left navigating a confusing, uneven landscape of gun laws that change from one zip code to the next. That's why many of us in the Second Amendment community are turning our eyes toward the federal level, looking for comprehensive solutions like national reciprocity. The concept isn't new, but rulings like Hoffman breathe new life into it. They offer proof that the courts are finally calling out these residency-based restrictions for what they are, unconstitutional. So while we celebrate this moment, we also need to stay realistic. Hoffman is a step forward, not the final victory. If we want real, lasting protections that apply across all 50 states, that will have to come from Congress or the Supreme Court. This ruling reminds us what's possible, but also what's still ahead. Community feedback, raw and real. No court decision exists in isolation. In the weeks since the ruling dropped, gun owners, especially those stuck behind the California line, have been sounding off. Some are hopeful, others are downright furious, calling it a hollow win, and many are somewhere in between, encouraged by the momentum but wary of getting their hopes up. And honestly, that skepticism is valid. The gun-owning community isn't just one group. It's working parents worried about home defense in cities where crime is spiking. It's small business owners navigating threats in bad neighborhoods. It's military veterans fed up with being treated like a liability. It's people from every walk of life who just want equal protection under the Constitution. To many of them, a win that doesn't lead to immediate, practical results barely feels like a win at all, and they're right to feel that way. The truth is, real change doesn't usually happen all at once. It comes piece by piece, case by case. Lawsuits like Hoffman set the stage for bigger moves down the road. They shift the burden of proof. They create opportunities for other cases to build off their foundation. So while we hear the frustration, we also know this is how the fight goes. This isn't about pretending that one court ruling fixed everything. It's about recognizing that the wall of anti-gun regulation has started to crack, and now it's up to us to widen the break. What comes after this? Legal victories only matter if there's follow-through. That means more lawsuits, smarter legal strategy, and focused political pressure on judges, on lawmakers, and in the court of public opinion. We're already seeing movement. Advocacy groups are exploring how Hoffman can be used to challenge California's other licensing roadblocks. Attorneys are reassessing how to take on permit delays, arbitrary denials, and uneven enforcement across counties. And regular folks are realizing that this ruling might give them the legal edge to push back. But here's the risk: California's political machine is quick to adapt. If they can't block you directly, they'll find a workaround. Bills like Assembly 1078 are proof of that. Every new piece of legislation needs to be scrutinized down to the last sentence. When laws are passed in reaction to court losses, they rarely favor liberty. This is where endurance comes in. One win doesn't fix a broken system, but it gives us a platform to demand better. Every court case that follows should point back to the same principle. Rights are not defined by your zip code, your income bracket, or which county clerk happens to be on duty that day. They belong equally to every American. The next steps won't be flashy. There won't be headlines or victory parades, but they matter, because whether Hoffman becomes a precedent or just a passing moment depends entirely on what we do next. Final thoughts: a spark, not a finish line. Victories like this don't come often in places like California. This wasn't the knockout punch to the state's entire system, and it doesn't solve everything we've been fighting, but it does matter. Each successful challenge against unconstitutional laws moves the needle. It lays a little more groundwork for broader change. It may feel small now, but momentum builds one battle at a time. If this deep dive helped bring things into focus for you, or sparked your own thinking on where we go from here, sound off below. Share it with someone who's been watching this case from the sidelines, and stay sharp. The Constitution won't defend itself.